Fulton versus City of Philadelphia was a 2021 case that many thought would decide the debate between LGBTQ+ rights and religious freedom. However, the Supreme Court doesn't like to answer this question, and they always find a way to dodge it.
Why are you running? Why are you running?
In this video, we're going to cover how Fulton versus City of Philadelphia got to the Supreme Court, the court's decision, and the case's impact. But first, a dramatic recreation. Ah, what a beautiful day to be the City of Philadelphia. Time to read the morning paper and hear about how great we are. Oh my goodness! What is this? Catholic Social Services doesn't certify same-sex couples to foster? What? This is terrible. I gotta do something right now. You. Me? Yes, you. I've got a problem with you, Buster. What problem? What did we do? According to this here paper right here, you don't certify same-sex couples. Is that true? Oh, yeah, it is. Why? Well, see, we're a Catholic organization, and according to our beliefs, marriage is a sacred ritual between one man and one woman. When we certify a couple to become foster parents, we see that as an endorsement of that couple. So if we were going to certify a same-sex couple, it would be like saying, we support you, when we don't. So it goes against our religious beliefs. Oh, and besides, same-sex couples don't come to us to get certified anyway when there's already 27 other organizations in Philadelphia that would. We've never had a same-sex couple attempt to get certified by us because that would be stupid. Oh, religious beliefs. Look right here, Buster. You see this? Yeah? This is your foster care contract with the city. In it, it says that you shall not reject prospective foster parents for services based on their sexual orientation. Yeah, but there is an exemption. No buts. Now listen here, Buster. Until you get your act together and start certifying same-sex couples, I'm afraid I'm gonna have to revoke your privileges to certify couples for foster care. What? You violated our contract. It's only fair. What the heck, man? What about our free exercise of religion? Yeah, what the heck, man? Now listen here, Sharon. This Sharonell, this doesn't involve you. Why, yes it does. I fostered over 40 children from CSS, and I still use their services. If you take away CSS's foster care privileges, that directly affects me. CSS, sue their ass. Whoa now. Listen, CSS. We don't have to get nasty now. All you have to do is start certifying same-sex couples, and then we can go back to the way things were. Pretend that this never happened, you know? It doesn't have to get ugly. Philadelphia, I'm afraid you violated our right to free exercise. I'm gonna have to sue you. Things didn't have to be like the CSS, but we both must do what we must do. I'll see you in court. And scene. Thank you very much. I will take my 100 now. Thank you very much. So yes, the City of Philadelphia revoked CSS's certification abilities because they did not certify same-sex couples. CSS believed this was a violation of the Free Exercise Clause of the Constitution, so they sued the city. What might be the Free Exercise Clause, you might ask? The Free Exercise Clause is within the First Amendment of the Constitution, and it says that Congress shall make no law prohibiting the free exercise of religion. To make a long story short, the case would eventually make it to the Supreme Court, who wanted to answer 3 questions. 1. To succeed on their free exercise claim, must plaintiffs prove that the government would allow the same conduct by someone who held different religious views, or only provide sufficient evidence that a law is not neutral and generally applicable? 2. Should the court revisit its decision in Employment Division v. Smith? And 3. Does the government violate the First Amendment by conditioning a religious agency's ability to participate in the foster care system on taking actions and making statements that directly contradict the agency's religious beliefs? But to be completely honest, I've read the majority opinion like 2 times, and I cannot for the life of me find an answer to the first question, so we're just going to, yeah. Anyways, for the astute viewers watching, you might notice that another Supreme Court case is mentioned, Employment Division versus Smith. Smith is an extremely important precedent for this case, so in order to fully understand Fulton, I have to do another mini Supreme Court case brief on Smith. So let's just... There we go. Employment Division versus Smith is about 2 Native American men who were fired and denied unemployment compensation because they smoked the illegal drug peyote as part of a religious ritual. They sued based on the Free Exercise Clause, and the case would go to the Supreme Court. In a 6-3 decision, the court would actually rule against the Native American men. This is because, according to the majority, neutral and generally applicable laws do not violate the Free Exercise Clause. What does this mean, you might ask? Well, a neutral law is one that is not specifically directed at religious practices, while a generally applicable law is one that applies across the board regardless of religion or religious motivation for a certain prohibited action. According to Smith, a law is no longer generally applicable when there is a system of individualized exemptions in place. Remember this, because it will be really important. Which now brings us to the decision in Fulton versus City of Philadelphia. So, the stage has been set, the arguments have been made. Who will the Supreme Court rule in favor of? In a unanimous 9-0 decision, the Supreme Court ruled in favor of Fulton and CSS. But wait. Before your religious freedom enjoyers start celebrating too much, let's look at the majority opinion of the actual decision, because you'll soon see that this victory isn't as satisfying as it seems. So what did the majority base their decision on? Well, according to Chief Justice John Roberts, the foster care contract that Philadelphia had with CSS was not generally applicable. Why is this? Well, in the foster care contract's anti-discrimination clause, there was an exemption in place. If you'll remember from Smith, when a system of individualized exemptions is in place, a policy is no longer generally applicable. This means that instead of using the precedent set by Smith, the case must instead use the old standard of strict scrutiny. This is significant for 2 reasons. For one, since Fulton doesn't need Smith to be decided, there is no reason to consider whether Smith should be overturned. And 2, it will be much more difficult to rule in favor of Philadelphia because strict scrutiny is incredibly difficult to pass. And, as we can see from the final decision, Philadelphia's policy did not pass strict scrutiny. According to the majority, the city did not have a compelling reason for denying CSS an exemption to their anti-discrimination policy. The only reason the Supreme Court really considered weighty was the city's interest in protecting LGBTQ+ foster parents from discrimination. But Roberts says that that interest is not enough. So, in the end, the Supreme Court ruled against Philadelphia based on extremely narrow terms, saying that forcing CSS to certify same-sex couples is a violation of the Free Exercise Clause. Even though the decision was unanimous, there was actually a lot of disagreement over the technicalities of the case, specifically surrounding the question of whether to overturn Employment Division versus Smith. This is because Smith was an extremely unpopular case that many religious organizations wanted overturned. There were 3 concurrences written for this case, some longer and more impassioned than others.
Oh, brother, this guy stinks!
In Amy Coney Barrett's short concurrence, she essentially says, yeah, I like the decision, although I do see why some people want to overturn Employment Division versus Smith. I don't think that's something we need to do right now, smiley face. Pretty simple, right? Let's move on to Alito's concurring opinion.
Oh my god, bro. Oh, hell no, man. What the fuck, man? Get your ass on.
Yeah, Alito's opinion is 80 pages long, and not only is it 80 pages long, it's a boring 80 pages long. And because I'm trying to keep this video relatively short, what you need to know about Alito's opinion is this. He's really mad that Employment Division versus Smith wasn't overturned. Like, really mad. Like, write 80 pages about it type of mad.
Nastiest skank bitch I've ever met. Do not trust her. She is a fugly slut.
And in his very long opinion, Alito essentially makes the argument for why Smith should have been overturned. Finally, we have Gorsuch's concurring opinion, where he essentially makes the same arguments as Alito. He agrees that Employment Division versus Smith should have been overturned. However, Gorsuch also disagrees with how the majority came about the decision, saying that they relied on too many technicalities and ignored the big picture issues. But it doesn't really matter, because the majority made their decision, and now we all have to live with it. Or do we? Yeah, this case is kind of useless. While it is very easy to be concerned over this case as an LGBTQ+ individual, this case won't actually have that much of an effect. This case was ruled on extremely narrow technicalities in Philadelphia's contract, meaning that the case will only really impact Philadelphia foster care agencies. However, this case does do one thing that is monumental. It actually gets the religious right and the LGBTQ+ community to agree on something. Yeah, I don't think anybody likes this case, like, at all. Conservatives don't like this case because it didn't overturn Employment Division versus Smith, and liberals don't like this case because it didn't protect the LGBTQ+ community. So yeah, nobody is happy with this decision, except, I guess, the Supreme Court, because they get to push off making a decision on religious freedom versus LGBTQ+ rights to another day. If you came into this video expecting to learn where the Supreme Court stands on religious freedom versus LGBTQ+ rights, I'm sorry to disappoint. For some reason, the court is incredibly hesitant to make a definitive decision on the issue, and they always find some way to dodge around it instead of providing a direct answer. And the fact of the matter is that it is a very complicated issue. I mean, at what point does protecting religious freedom cross into the territory of discrimination? Well, I can't answer that question for you. And apparently, the Supreme Court can't either. This has been my Supreme Court case brief. I'm done now. Thank you so much for watching. I hope you've learned something. Goodbye.